Okay, hello everyone. Thanks for joining us this morning, this afternoon, this evening, depending where you are on the planet. My name is Ray Millien. I'm the General Counsel and Corporate Secretary of Exro Technologies. I'm leading off Frontier by Patsnap today. And we're going to talk about sort of AI in IP, and more specifically in the IP practice of law, and bridging ethics and efficiency in our modern practice. So let's begin. So, of course, being a legal presentation and being a lawyer, we always start with sort of the disclaimers. So this presentation is, in my humble opinion, it reflects my current personal views and shouldn't be attributed to any current or former employers or their clients or customers. This was not created using AI. I did this presentation the old-fashioned way. I actually researched, read articles, took classes, and authored it myself. Did not use any AI tools in its creation, despite the topic. So that being said, today I'd like to, given the technology, make this somewhat interactive. So therefore, there's no such thing as a stupid question, only stupid answers, to quote our former U.S. Secretary of State, Colin Powell. So we'll take questions via the chat. We'll have some Q&A at the end. If the moderator, Kate, has questions, can type those questions during the slide, I'll take those as well. Okay, so let's get to it. So before we talk about what we're covering today, let's talk about what we're not covering. Today there won't be sort of like an in-depth technical discussion of AI or Gen AI. I'll leave that to the engineers. Although we'll do a brief discussion at a lawyerly level. We won't be talking about AI legislation, what's going on in the EU and California and other places, and regulation being promulgated, sort of like executive orders. Again, today we're going to focus on ethics. I won't be talking about any specific AI tools or the big thing that's going on, whether AI can be an author for copyright purposes or an inventor for patent purposes. Again, that can be an entire seminar or a conference in of itself. We also won't be talking about sort of the big cases of copyright issues surrounding training data or the ethics in building and deploying AI tools. We're simply going to talk about what is the ethical use of AI as an IP practitioner, if you're an IP attorney, more specifically a patent attorney, trademark attorney, patent paralegal, patent agent, so on and so forth. Okay. And the last thing I will not cover today is what Forbes interestingly asked over 5 years ago is, will AI put lawyers out of business? And so I know that's prevalent on a lot of people's minds, but I'm going to guess the answer is probably no if I have to be a futurist today. Okay. So, AI has been around for a long time, right? It was invented in the 50s in Dartmouth College. It's grown significantly. I took AI as a course in the 1990s at Columbia Engineering. So why are we talking about AI today? And why is it so big today? Why are there so many conferences? Why are there so many seminars and courses and masters and certificate programs on AI? And I think it's because, Chat GPT was released around 2022, 2023, and that sort of gave a renaissance to the power of AI. But sort of how did we get here? Well, from a technological standpoint, I could break it down to two things. One is sort of like increasing available data and an increase in computing power. On the data side, when the IoT, where everything now has a chip, everything now is connected to the internet, right? So you have an increase in a number of devices to the internet, creating more data. And now there's been a significantly lower cost to store data, right? Storage used to be tremendously expensive. Now with, there's a lot of different services where you can store data pretty cheaply. And now you also have access to cloud storage, whether it's Google Cloud, AWS, or Microsoft Azure. There's a significant access to cloud storage to store all this data that's being connected to IoT devices. And there's also been a significant advancement in battery technology. And if you think about that for a second, it seems kind of strange. Why are we talking about battery technology? But if you have your phone and your phone stays on longer, right, then it's the more amount of data it's sending to the servers, and therefore that's the more amount of data available to train AI systems. So advances in battery technology can't be overlooked. And all of this has resulted in the increase in data being collected, which can train AI systems. On more the hardware side, there's been an increase in computing power, right? So you have an improved semiconductor technology, faster GPUs, with NVIDIA creating AI chips, and Intel and TSMC following suit, and some other chip startups. You also have the lower cost of cloud computing. If you think about infrastructure as a service, now every startup can have access to supercomputers, and they don't have to actually buy the hardware. And then you have improved mobile networks like 5G. So all of this has reduced the cost of transporting the data from the field, from the IoT devices, to where the AI scientists are working. And all of this has resulted in an ecosystem for better software. So we keep talking about AI, and I'm on slide 7, but I haven't defined AI. Well, I guess AI means different things to different people. But I think being IP practitioners, where did I go to look for a definition of AI? So WIPO, the World Intellectual Property Organization in Geneva, has their definition, which is it defines it as a discipline of computer science that's aimed at developing machines and systems that can carry out tasks considered to require human intelligence with limited or no human intervention. Okay, but you have to know sort of like AI is sort of a moving target. What was AI in 2000 is now just data processing. What's AI in 2024? In 2026, we'll be like, oh, that's just data processing. So, for the patent attorneys in the crowd, I think a good way to think about it is AI is sort of like using a means plus function claim under 35 USC 112 F, right? We tend to talk about AI more in terms of the results than the means or step, to perform a specified function, right? So, we don't recite the structure, the material, or the acts. We just tend to talk about the results or the specified function. And that's a good way to sort of think of AI. It's a moving target, but, it is what it is. So, when we talk about AI, I said I wasn't going to get, too technical, but I think, we need to sort of like define what areas of AI are we talking about, right? So there's more like traditional or good old-fashioned AI, which is natural language processing, symbolic AI, or expert systems, like, sort of teaching a computer to play chess. But then, we get into the more interesting aspect of a subset of AI, which is machine learning. So now you have algorithms that allow an AI system to learn from experience without being explicitly programmed. And then a subset of that machine learning is sort of deep learning, where we use artificial neural networks, which is just, think of it as a data structure that mimics the human brain, right, to learn from data. And it's called deep learning because the data is passed one layer to another, which each layer adding a mathematical operation as the data trains the model. And then we get the generative AI, right? So this is where really we start getting interested as IP practitioners, right? And these are the deep learning systems that are capable of not just searching for prior art or searching for prior trademark registrations or searching for, keywords in a big database, but these are systems that can generate entirely new content in the form of text, imagery, video, music, and even computer code. And then as a subset of Gen AI, we get to these large language models, right? So these are models that are trained on massive amounts of data to achieve advanced language processing. And then even a subset of that is foundational models, right? So these are LLMs that are fine-tuned to perform specific tasks. Curiously, if you look at just the Gen AI that subset, as of September 2024, there were about 39,000 patent families globally just covering Gen AI. with a whopping 68% of those originating from China. And then, the rest is the usual suspects like Microsoft, Google, Samsung, and IBM. So there's been a tremendous increase in filings in this area if you sort of look at technology trends from a patent lens or a patent filing lens. So then, even more interestingly, if we dig down more into Gen AI, this is sort of like, a taxonomy by Databricks, a Gen AI company that provides tools. Again, they define LLMs as models that are trained on massive data sets. And then foundational models, like GPT, which are generative pre-trained transformers that take these large LLMs and then train them for specific tasks. And then I'll do a little sidebar here, right? There are a lot of vendors or people or institutions or entities that claim that, we have, we trained our own LLM. We have our own large language model, right? And then, so I just tell people to be careful when people say that, because, to train an LLM, usually takes about $100 million, right? Like OpenAI spent $3 billion in fiscal year 2024 just training ChatGPT. And that's 3 billion with a B, right? And then, to even do that training, to train ChatGPT took enough electricity to power 50 US homes for 100 years, right? And there's a prediction by 2030, AI applications and data centers will consume 9% of all the energy consumption in the US. That's why you read about Google and Microsoft, going back to nuclear power and using, 3 Mile Island and things like that, because, that's truly green energy, because it takes a massive amount of money, a massive amount of electricity to train an LLM properly. So just be wary about entities that say, we have our own LLM. So, I just always take that with a grain of salt. So what are sort of like, if we drill down just at Gen AI, right, that can create content, answer questions, be a virtual assistant, have do large language style transfer, storytell, create poetry, and even generate code, what are the use cases for IP practitioners? Like, why do we care? Well, obviously you can use it for IP legal research, drafting opinions, patent landscaping, e-discovery in an IP litigation, drafting USPTO office actions, drafting even patent applications, creating IP license agreements, summarizing IP licenses in a due diligence, drafting a Court of Appeals Federal Circuit brief, or even drafting district court motions in an IP litigation. So these are all the use cases, and not all these use cases are Gen AI, right? Doing legal research is just, more natural language processing, that, the Lexis and Westlaws of the world have been offering, since we were all in law school for free. So these are the use cases. Okay, so now we're finally getting to ethics on slide 11. Okay, Ray, thank you. We wanted to talk about ethics, but I had to set the scene. So why do we have legal ethics, right? Well, if you look at the ABA model code, it tells you it's to maintain the integrity of the profession and to protect the public, right? So I don't care what jurisdiction you practice in. I don't care where you went to law school. I don't care what area of the law you practice in. How to be ethical boils down to 2 rules, right? It's 1, be competent, and 2, don't lie, cheat, or steal. I don't care what part of the model code of the ABA you cite, or New York's ethics rules, or Florida's ethics rules, or California, Illinois, Wyoming, Wisconsin, Texas, District of Columbia, Puerto Rico, it does not matter. All the rules boil down to be competent and don't lie, cheat, or steal. So how do we do that when we are practicing IP law or IP practitioner and we're using AI tools? Well, all the concerns boil down to 4 things: accuracy, privacy and confidentiality, responsibility and accountability, and bias and discrimination. Now, I'm not even going to talk about bias and discrimination. 20 states have adopted Model Rule 8.4G in 2016 that says it's misconduct for a lawyer to engage in discrimination based on race, sex, religion, national origin, ethnicity, age, so on and so forth. So the AI tools that we really worry about bias and discrimination, typically pop up in criminal law, where people are using facial recognition software to identify suspects and the biases in those that we read about in those horror stories, or, in court systems to detect lies and whether, those were coded in a way that's discriminatory. So we won't talk about bias and discrimination as IP practitioners. We'll focus on accuracy, privacy and confidentiality, and responsibility and accountability. So the main concern we'll first talk about is accuracy. And so what do we mean by accuracy when we talk about AI tools? Well, we're really talking about the phenomenon known as AI hallucinations. That's where a large language model perceives patterns or objects that are non-existent and create outputs that are nonsensical or altogether inaccurate, right? So another way to think about it is a large language model is really a next word prediction engine, right? And hallucination happens, in its most vanilla form when there's no concept of fact, right? They're predicting next word based on something, what they've seen so far. It's a statistical estimate, and sometimes that estimate is wrong. And how is this a danger, right? Well, there was a study published by Stanford University in 2024, and they looked at all the, GPTs available out there, OpenAIs, Google's, Meta's, and they found that they were wrong 75% of the time when you asked it a legal question. Now, think about that. I can't think of an industry where being wrong 75% of the time is a good thing. Well, maybe baseball, right? Because if you bat 250, you can still make $5 million a year. But other than baseball, right, being wrong 75% of the time is not a good thing. And this all came to light really in the recent case, Mata versus Avianca Airlines, right? So that was when Judge Counsel in the Southern District of New York sanctioned two lawyers for submitting a brief. It was I think it was an opposition for a motion to dismiss in a tort case. It was in federal court because it involved the airline, and there's some obscure federal statute that's a federal question. And they were citing non-existing cases, and because they used I think a open source tool. I think it was ChatGPT. And it hallucinated, and it was citing cases that didn't exist. And Judge Counsel said something very interesting. He says, technological advances are commonplace, and there is nothing inherently wrong or improper using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. And I think the existing rules are the existing rules of ethics. In this case, Judge Counsel used Rule 11 of the Federal Rules of Civil Procedure and sanctioned the attorneys. And I think the sanction was really interesting, right? It was only a $5,000 monetary sanction against the lawyers in the firm, but he made the lawyers in the firm write sort of like basically an apology note to each of the 6 judges that were attributed to the cases that were falsely cited or falsely created. And I think when that was widely reported, that sort of brought the sort of Gen AI problem to the legal community and to the popular press. So sort of in reaction to that, the state bars, not to be outdone, have sort of, decided, oh, well, we'll start promulgating rules or opinions or guidelines or FAQs with respect to AI, and more specifically Gen AI. And so, I list here, the slides will be available afterwards. California, Florida, New Jersey, New York, the District of Columbia, Michigan, and Pennsylvania, are some of the early movers in adopting either rules or opinions or FAQs with respect to AI use. Some courts, like the Eastern District of Texas, the Eastern District of Michigan, the Michigan State Courts, and the Fifth Circuit, all have guidance or proposals. And of course, the ABA in Formal Opinion 512 that was released in July of this year, it gave a formal opinion about Gen AI usage and the ethics of that for lawyers. And not to be outdone, the USPTO has also issued their own guidelines on the use of AI. But, at the end of the day, you can read all these, and at some point, all of these taste like chicken, right? And they could all be distilled into 6 points. right? And I'm going to use the model rules because, I think over 40 states have adopted them. So I'll just use those as the majority case, right? And the rules boil down to 6 things. The first is model rule 1.1. Are you competent, right? Because it says a lawyer shall provide competent representation to a client. So from the AI perspective or a Gen AI perspective is, do you understand the AI tools you're using? Rule 1.4A2, communications, right? Are you informing your clients that you're using or not using Gen AI tools and the risks and limitations of those tools? Rule 1.5A, fees. You have to charge a reasonable fee. So are you charging for work that's done by an AI tool, right? If you knew the patent application or the trademark search usually takes 2 hours, you did it in 5 minutes using some AI tool, are you still billing for those 2 hours? Rule 1.6C, confidentiality, right? You have to make a reasonable effort to prevent the inadvertent disclosure of your client's confidential information. Well, what happens when you enter a prompt into a open source or a public AI tool, right? Are you disclosing confidential information, right? Fifth point, Rule 5.1A and 5.3B, the duty to supervise. So in 2012, the rule in 5.3 was changed from the word to you have to supervise your assistants to you have to supervise your assistants, right? So the ABA is taking the stance that AI tools are non-lawyers' assistants, and you have to supervise those, right? You have to make sure that the use of those tools conform to the rules of professional conduct, just like you would supervise a paralegal or an executive assistant. And last but not least, misconduct by dishonesty under Rule 8.4C, right? So it's misconduct to engage in fraud, deceit, or misrepresentation. So in other words, are the outputs of your AI tools hallucinating by citing non-existing opinions, inaccurate analyses of authority, or using misleading arguments, right? So it all boils down to that. Now, when you go through this, the rules state by state, there's some interesting, state tidbits, right? So the New York State Bar has a sample engagement letter provision that says you're going to use AI tools, right? And that may satisfy that, according to the New York State Bar, will satisfy informing your clients and not having to do it on a case-by-case basis if you just put it in the rep letter. Not all states agree. Florida has an interesting tidbit. Florida, home of attorney advertising, says if you're using a chat GPT chat bot, right, you have to disclose that it's lawyer advertising and that it's an AI program and not a lawyer or employee of the firm answering the questions. And the DC Bar had something very unique of all the state opinions that I've read. They were citing Model Rule 16, which is also their Rule 16, that says when a client terminates you, you have to give them the entire file. And, so the DC Bar is saying, well, the entire file might actually have to include the thoughts and strategies of using an AI tool and the specific interactions with the AI tool, including what you enter into the prompts. So that seems like a litigation nightmare to me, but, that's the DC Bar opinion. So not to be outdone, the USPTO, for patent and trademark attorneys and practitioners and agents practicing before the office, they have, also issued their own guidance. And this also boils down to 6 points, like I mentioned, all of these sort of taste like chicken, and so they cite the duty of candor under Rule 56 or Rule 555A if you're in a re-exam, right? And the duty of candor from an AI perspective is, do you have to disclose that that you use AI tools by the inventors or the parties or the practitioners that are material to patentability? Under Rule 1118, when you sign or certify, you're certifying it's not for improper purpose, that it's true, so on and so forth. So again, this is the hallucination problem, right? So the natural person signing, right? If they're have they checked the AI tools to make sure it's accurate, right? Are you submitting AI generated samples for your trademark to prove use of commerce? So again, using hallucinations, but they're going about that through the signature requirement. Confidentiality, again, Rule 11.106D at the USPTO OED is the same as Rule 1.6 of the ABA, right? So in other words, when you're entering things into the prompts, right, are you disclosing confidential information if you're using an open source tool or a public tool? The fourth point here, foreign filing license. Now, this is interesting, right? So again, an invention made in the US needs a foreign filing license before you file abroad. But what happens if you're using an AI tool where the servers are located outside the US? Have you violated that rule? Very curious, very interesting. Competence, again, do you understand the AI tools and do they violate any duties owed to your clients? And last but not least is very curious. The PTO, they said, forget the rules. Let's go to contract law. Look at the terms of use of the USPTO website, right? And, you know, the terms of use prohibit unauthorized access, right? And the only people authorized to use the USPTO website or certain portions of it are registered practitioners or people who are registered to use those tools. So if you have an AI tool that's data scraping or data mining, that violates the rules. That violates the terms of use. So the PTO also talks about contract law, which I find also interesting from an ethics standpoint, where they're not mentioning any of the rules of from the based on the ABA model rules. So I say they all taste like chicken. I've cited lots of rules, lots of questions. So what is your takeaway? Well, I'm going to have just 8 simple takeaways for you, right? The first takeaway that you could install in your practice is treat AI like you would a paralegal. You would fact check his work. You would build upon the suggested research. You may rewrite some content, and you may enhance the legal arguments that the paralegal prepared. So just treat AI like you would a paralegal. Supervise it. Number 2 is AI tools are complements and not replacements. Okay, it's a complement to your practice. It doesn't replace your professional judgment. It doesn't replace your education, your scientific training if you're a patent attorney or a patent agent. It doesn't replace your legal training if you're a paralegal or attorney. So they're complements and not replacements. Right. The third takeaway is you should review and negotiate the terms of service of the AI tools you are using. Right, especially the privacy, security, and IP ownership clauses. Because if you're using sort of like the public chat GPT, OpenAI's terms of use will tell you that, we're going to use your personal information to improve our services. And anything you enter, anything you input or you upload is going to become ours. And they even have a clause that says it becomes an asset of the company, which we can sell in an M&A. So if you're using a private tool and you can, negotiate those terms of service. And number 4 is understand the capabilities and limitations of the AI tools you use. So there's no need for you to be a sort of an AI expert or a statistician or a data scientist or a computer scientist, but you should at least understand the capabilities and limitations of the AI tools you're using. It is no different than when you're doing a prior art search and you're only searching US or you're only searching European or you're only searching Chinese patents or you're only searching Korean patents or you're only searching the big 5. Right? Understand the capabilities and limitations of the AI tools that you use. Again, this all goes down to be competent, don't lie, cheat, or steal. Takeaway number 5. Tell your clients if you are or you're not using AI tools and their risks and limitations. Okay, so, the Florida bar says if you're using an internal AI tool, you don't need to tell your clients. If you're using an external tool, you should. Right? But that's Florida, right? So in the jurisdiction you're in, do you need to tell your clients that you are or are not using AI and the risk and limitations of those tools? Again, see the New York bar where they have sort of like a blanket statement in the rep letter, a sample paragraph. Number 6 is you should have a permissible use policy within your firm, within your organization, within your nonprofit, within your company, within your law firm of what tools are we going to use, what's permissible, and provide training to your people, right? You have to supervise them, be competent, make sure everyone's competent. Number 7, this goes without saying, but don't charge hourly fees for the work done by the AI tool, okay? Don't lie, cheat, or steal. And number 8, check the local rules of the courts, the tribunals, and the offices you practice for, and do they have some specific rules about AI tools. And those are the 8 takeaways. But I have a closing thought. So we all, I spent sort of like the last 30, 40 minutes talking about the ethical use of AI tools, right? But what if you say you don't want to use AI tools, right? And, a recent survey said only 43% of US attorneys use AI tools professionally, right? So it's still sort of like minority, right? So there's a lot of people that are saying, 7% are saying that we're not using AI tool in our practice, right? But think about it. Would you not use email? Would you not use spell check? Would you not use cloud backups? Would you not use the internet? Would you not use e-filing in today's day and age? So if you look at Model Rule 1.3 that says a lawyer must act with reasonable diligence and promptness in representing a client. So if you read Model Rule 1.3 in conjunction with Model Rule 1.1, comment 8, which means you have to be technically competent, and the PTO has their own version, Rule 11.101, right? And then you read that in conjunction with Rule 1.5 that says you have to charge a reasonable fee. If you're not using AI, for example, to do e-discovery, are your fees too high and is your timing too slow? So, the whole ethical use of AI can really boil down to not about utilization, but underutilization. So I guess at the end of the day, what I'm saying is just keep calm and use AI ethically. And folks, that's all I have for you. Thank you for your time and attention. For those of you on the West Coast, I know it's bright and early. And at this point, Kate, I will take questions if there are any.
We do have a couple of questions that have popped in. And I have some questions myself.
Sure.
So the first one is, do you envision the use of AI increasing in the law?
Absolutely. Absolutely. There's no doubt about it. I mean, AI is no different than sort of like what e-filing was or email was, 20, 30 years ago when Al Gore invented the internet. I mean, it's just that it's going to become a tool. And the penetration of AI tools, not surprisingly, is more within in-house legal departments than it is at law firms. There's been more of a resistance at law firms and sort of a challenge to the billable hour within law firms. But, I think in-house legal counsel by far have been adopting and embracing AI tools more as a cost savings measure, because chief IP counsels, general counsels, chief trademark counsels are always under cost constraints. And so I think you'll definitely see the use of AI tools increasing in the law for sure. And we're already using AI tools, right? If you're using Grammarly or spell check within Microsoft Word, it may not be Gen AI, but it's definitely AI, right?
Yeah, 100%. I see we've had another one come in. Somebody's quoted you, "Don't cheat and steal." Nice one. But how do we prevent bad people from doing so?
Look, at the end of the day, there are always going to be bad apples in the crowd, right? And so how do we prevent, attorneys from lying, cheating, and stealing? I mean, I think it's the way we always do it, right? Under most model rules, if you're aware of it, you have a duty to report that attorney. Every state bar has a discipline procedure and a discipline reporting, whether by the public or fellow attorneys. The industry has always been a self-policing industry. I don't see that changing. So, I think that question is more towards, the use of AI tools, in cybersecurity and so on and so forth. That's a little bit outside of my lane, but I know within ethics, usage of AI tools within the legal profession, it has to be self-policed and it has to be self-reported. And I think, the public will play a good role in that too, as they always have by reporting attorneys who are overbilling or, lawyers being sanctioned by judges for citing cases that don't exist, opposing counsel, site checking and checking the references. Or the citations, I should say.
Yeah, hopefully that answers your question. I think it's sort of that a matter of everybody doing their part. There'll always be those people kind of thing. Another question that's come in is, how much consideration is currently given to AI-generated IP when filing patents?
So again, I think the PTO guidance has been very clear, right? So, you could sort of have like some AI-generated content in a disclosure, But when it comes to actually drafting the claims, under the duty of disclosure, you may have to disclose that an AI tool was used. And then again, you have to write claims based on what the human intervention was, or, it's anything under the sun made by man, right? If I'm going to quote, 101 case law. Again, you have a duty of disclosure, and it's always been a self-policing. But you know what? Opposing counsel, if that patent gets litigated, I think everyone will check, the inventors will be deposed. So I think the consideration is everyone has a duty of disclosure under Rule 56, and the guidance is clear. Even the Copyright Office is also clear about, filing copyright registrations for AI generated content, that it should be done only for the human portion of that content.
Yeah, 100%. Hopefully, Zoran, that answers your question. My personal question for you, Raymond, is sort of twofold. Is what are you most excited about for the future of AI in IP? I'll start with that.
Well, I think at the end of the day, I think it's a usage that's not even sort of like the best, Gen AI usage. But for me, it's, sort of like doing a prior art search and being able to do that using natural language, right? And having that come back with like a small subset of relevant patents, so the vendor Patsnap that solves that for me, I think I think that's the most interesting use case for me. Will we get, as in-house counsel, will we get to the point where AI can sort of draft a patent application? I don't know if we're there yet. Maybe we're there, and then you treat it like a paralegal, and the attorney actually takes the first draft and actually goes through it and then puts their human judgment on it. But for me, being in-house counsel, being able to get a quick, reliable subset of data using natural language and not being the most well-versed in the technology, because, when you go from sort of financial services to automotive to healthcare, at some point it becomes widgets, and your engineering degree gets older and older. So being able to describe an invention and really getting a quick gut check about where I could put my resources would be awesome.
Amazing. I think, oh, nope, we've had another one come in. I was going to say, I think we've run out, but we've had another one. As AI advances, will legal services become more accessible to those who need it?
I think it could do good, right? Just like AI in healthcare can help with diagnosis and remote diagnosis where there's a dearth of qualified medical personnel. I think in the legal industry, I think it can. But again, those tools will have to advance. They'll have to be supervised by actual attorneys. And, like the Florida rules state specifically, the public will have to know that this is just a quick answer. This is just a preliminary thing, but you need to see a human lawyer that's up to date with the law, that can install that professional judgment. But, again, I think, where there's a dearth of legal representation based on financial resources, at some point, sure, they can help.
Yeah, I think that should be a good answer. Hopefully that answers your question, Christopher. We've had some late questions come in. People, I think they've had some more thoughts. But from Angela, we have, if an AI tool anticipates an application for an invention that the inventors did not anticipate, isn't that quote unquote cheating, even if only in the spec and not the claims?
That's a brilliant question. And I'm not sure if I have an answer to that. I guess my quick gut is, the law and the rules and the regulations and the standards of practice never evolve as fast as the technology. But as Judge Counsel said in the Southern District of New York, right, there are existing rules that put up guardrails, right? And one thing I didn't mention is, and Angela, I'll get to your question, but one thing I did not mention is, the hallucinations. As the hallucinations get out there and publish, right, and sort of become fake news, later AI tools, as they're training on data that's available on the internet, are actually training on hallucinations. So what happens when you have later AI tools training on hallucinations, right? You get this phenomenon known as AI slop. And at some point, the model breaks down because it's training on falsehood upon falsehood upon falsehood. So that shows you there's a tremendous first mover advantage in AI, because the people who train their models on the least amount of hallucinations have better models. So now I'll get back to Angela's question. At the end of the day, if it's public, it's public. I'm going to be honest, I don't know how to answer that question other than to say, I think it is cheating. And I think, you can't say something anticipates it unless it was out in the public. It can't be generated after the application was filed by an AI tool at the moment. So I would say, look, the traditional rules of prior art under 102 would apply. I don't see AI tools changing that. I'm sorry, Angela. It's a brilliant question. I'm not sure I have a really great answer to that.
Thanks, Angela. It's definitely been a thought-provoking one, but I feel like everybody's still kind of learning themselves as well. So
Sure.
We have had another one. Vincent has said, how do you think AI will impact the person of ordinary skill in the art standard?
Oh, Vincent, another brilliant question. So I think it will eventually, because a person of ordinary skill in the art, right? You can say a person of ordinary skill in the art using, email would be able to do X, right? So a person of ordinary skill in the art with access to some GPT would be able to do X. So I think at some point it could and will have an effect of a person of ordinary skill in the art, because it will become another tool, right? Just like, a hammer or a wheel, right? So I think, that's a brilliant question. And I think the answer is it will affect it, because it'll just become another tool. It'll become another arrow in the quiver of the person of ordinary skill in the art and the relevant technology, for sure. I love that. Angela and Vincent, I need some a license to your questions to add that to some article.
Amazing. Thank you so much. Oh, we have one more. I guess we'll do one more question, and then I think we'll have to cut it off. But thank you, everybody, for popping those in the chat. Lots of great engagement. Zorian, apologies if I pronounce your name wrong, but they said, we treat AI as we would a paralegal. Then wouldn't it be okay to consider AI suggested applications for an invention and use it?
It would be okay, and it would be okay to put it into your spec, but it wouldn't be okay to claim it according to the USPTO guidelines. And if it was on the copyright side, it wouldn't be okay to claim it in a copyright registration. You would have to segment what was suggested by the AI tool and what was created by the human author under the copyright guidelines as well.
Perfect. Hopefully that answers. And I think we'll close it out for questions now. But thank you so much, everybody, for being so engaged in the chat. And thank you, Raymond, for such a thought-provoking session and taking us behind the scenes of AI and ethics. I think the balance between that as well as efficiencies is really critical. And your insights have given us a lot to think about.
Well, thank you for having me, and I appreciate everyone's time and attention.
Thank you. And for everybody, we will have more sessions about AI later on today, specifically about Patsnap's AI. So if you found Raymond's session interesting, be sure you stay tuned later on for that, where we talk about Patsnap's LLM.